Good morning. I am District Associate Judge Karen Kaufman Salic. I would like to thank the Commission for the time and attention you've afforded my application. The commitment that you've shown to this process will benefit Iowans for many years to come, and on their behalf and mine, I thank each of you. Like many Iowa farm kids in the 1980s, I baled hay, primarily for my grandfather. Nothing could get me out of it. Allergies, whining, appealing to my grandmother for mercy. A couple years, my sister and I asked for a round baler from Santa. He failed us. Those are bigger and have to be lifted by machinery, so we were convinced that would let us off the hook. It did not, and so I took matters into my own hands, and at the tender age of 13, drafted a written contract with my grandfather that my sister and I would be out of the hay baling business as soon as we had baled our 1 millionth bale of hay. That admittedly was not great legal work, and a contract that I never fulfilled. He did release me from that to go to law school, so I appreciate that. Even with a contract with those terms that were not favorable at all, it did encapsulate a belief that I still hold today, that the law provides the right answer to anyone who needs its protections. And I have tried to abide by that in my practice of law and now as a judge. Of course, finding the right answer within the law is heavily dependent on the judge who is looking for the answer, which is why the qualifications of each applicant is so important. Hopefully, all 18 of us that you'll see today, which is a long day for you, but hopefully we all possess the threshold qualifications of being bright, hardworking, with an intellectual curiosity, an abiding love for the law, and an interest in public service. So deciding between us obviously depends on different qualifications. I think the important ones, that there's 4 main ones. 1, a depth and breadth of legal knowledge. 2, the ability to collaborate despite varied backgrounds. 3, neutral and efficient decision-making. And 4, providing clear guidance. As to the first consideration, the Court of Appeals reviews what trial court judges have done. I have been a trial court judge for over a decade now, and for the 15 years of my practice before that, appeared multiple times a week before many different trial judges. Therefore, I have a solid understanding of what a trial court judge should be doing. Additionally, 2/3 of the appellate cases involve criminal, juvenile, and family law, which squarely fits into my areas of specialization. The other 1/3 of the appellate cases include virtually all areas of law that I engaged in private practice and also during my civil and administrative obligations as county attorney. I would bring all of that substantive legal experience to the Court of Appeals and immediately be able to provide the resolution to appeals that was correct under the law. As to the second consideration, the Court of Appeals should ideally include a diverse cross-section of the community. Like a jury of one's peers, the mixed composition of this commission, decisions are better when it has been looked at from every aspect, and different backgrounds allow people to bring that full consideration. I am confident I will meld seamlessly into that environment, persuasively stating my position, but listening intently to others to consider all aspects of each case, reaching compromise if convinced my initial position was wrong, but if not, dissenting respectfully. The spirit of collegiality is very important to the Court of Appeals, and despite that collaborative aspect of appellate decision-making, I'm keenly aware that the Court of Appeals judges do the bulk of their work alone with the court file and with the law. So whoever selected needs to be able to work well in that environment by being motivated internally, having a great deal of independence, and have a full rewarding life outside of the profession to counteract that isolation. I have contended with that situation since my earliest days as county attorney through today in my current position. As to the third consideration, like the district associate court that I serve in now, the Court of Appeals is a high volume court, requiring a great deal of efficiency in making very difficult decisions. It is important to select nominees like me who have a long history of exercising sound, independent discretion, issuing decisions timely and correctly applying facts to the law without being swayed by sympathy, prejudice, or public opinion, and without being overwhelmed by the heavy burden of sometimes life-altering decisions that come before the courts. Finally, the opinions issued by the Court of Appeals must be correct, clear, and concise, not only because they provide a resolution to a specific problem for those parties before you, but also because they provide guidance about how trial court judges, attorneys, and the public should conduct themselves in the future. I've long provided such guidance to improve the legal profession and strengthen the public's confidence in case outcomes and in the legal process as a whole, not just in the rulings I write now, but in mentoring, encouraging, and educating judicial colleagues, attorneys, court staff, law enforcement, government employees, and the public. I trust that a full review of my qualifications resolves any lingering concerns that may have arisen from my ill-fated hay contract of my youth, and hope that each of you realizes how far this Iowa farm girl has come over the last 40 years to appear before you today. I am prepared to honorably serve in the Court of Appeals, backed by my comprehensive knowledge of substantive law, my fairness, my judicial restraint, professionalism, decades of consistent exercise of independent discretion and judgment, and quarter-century of commitment to the service of Iowans. If granted this opportunity, I will work hard each and every day in every case to provide all Iowans the answers required by the law and justice. Chairperson Valentine, I'd welcome any questions that the commission may have.
Thank you. We'll start with Commissioner Chase.
Thank you, first of all, for your application. Tell the commission how the skills that you learned during your time as a private practice attorney translate to the court.
I think it's important to have worked in the system in a lot of different perspectives. So having been, had a period of time where I had a direct client, obviously that also carries into when I was the county attorney, the county, all the officials, those were my clients as well. Having that experience, I think, gives you some insight into different strategies and how cases should be presented. I think it also gives me exposure to that substantive area of law in all of those areas that aren't necessarily as directly involved as what I do now as a district associate judge with criminal and juvenile. So I think that experience is very helpful and helps translate into what I would need to be doing on the Court of Appeals.
Thank you.
Commissioner Boyer.
No further questions at this point.
Commissioner Marquardt.
As a district associate judge, you've got significant experience with juvenile cases. How does that significant experience set your application apart from other applicants that we're going to hear from today?
I think one of the main issues, well, there's probably a couple. One is the importance of them. There is nothing more foundational to a person than their ability to be a parent, their rights to make decisions about their children and how their lives are conducted, even to have contact with them or be involved in any way in their life. When we have a termination of parental rights case, that may end a person's legal right to their child, and that's a significant burden that I think a person needs to be have already grappled with the seriousness of that, because it's a heavy burden. The other issue too is that those typically, unless it's a specific evidentiary issue of something that came in or did not, it's a de novo review. So the Court of Appeals is making the decision anew of whether or not a termination petition should be granted, if children should have been adjudicated, if they should have been removed. And I think having the pressure of a shortened timeline in those juvenile cases, and also the importance of having a permanent plan moving forward for kids that has been proven to be so essential, that it's helpful to have had a lot of experience in that in the past. It's a huge part of the appellate caseload. They come in very quickly. They need to be decided quickly, and having someone that knows how to make those decisions from day one, I think is very important.
Thank you.
Thank you.
Commissioner DeFort.
I have no questions at this time.
Commissioner Parrish.
Judge Stewart, I want to tell you I enjoyed our interview over Zoom. Tell me, though, with your background and experience, and particularly in the area of prosecuting cases, and I know you've served as an associate district court for a number of years, but I'm curious as to what you can tell folks who are interested in the criminal defense bar. What do you bring in terms of letting them know whether or not you can adjudicate their cases with a sense of fairness? Or what tools have you picked up in the other area that would help those of us who work in this area, that you can be a fair, I know all judges are fair, right? But you'd be a fair judge in those tough cases.
I think obviously I did defense work in my private practice, so I have that experience, ensuring that people's rights were honored by the opposing side, challenging that when necessary. As county attorney too, there's a number of ways you can be county attorney. One is, I think, what you see in the movies and TV where, people are pounding their fists and, just doing their job at any cost. That's not how I was county attorney. I viewed it more as an independent, objective role, while certainly an advocate for the state and involved in multiple prosecutions, that it was a public role that needed to act in the best interest of the public. And my expectation of all the officers, for myself, and what I advocated to the court was to be fair. I believe I shared a story with some of you that I had a defendant once who came in and wanted to represent himself. I had prosecuted him many, many times, and he told the judge during the colloquy, I don't need an attorney. She's always been fair to me. She's never given me anything more than I deserved. And I believe that's the right way to do that position, not as a sign of weakness, but making sure that you're guaranteeing that the people that come in accused of a crime are afforded every right that they have. I've carried that into being a judge, of course, which is much more neutral and not an advocacy role. But I believe that's one of the greatest foundations we have, are the protections that the law provides, and whether it's as a person accused of a crime, which is very serious, or someone who's maybe losing their rights, someone who has a contract that the breach of that has altered their life in unexplainable ways. It's important to be able to look at that objectively and be fair. And I believe that how I've done my job the last 26 years in the legal profession shows that I am fair to everyone that comes before me, regardless of my role.
Thank you.
Thank you.
Commissioner Graber.
Thank you for your application. I have no questions for you.
Thank you.
Commissioner Schnurr.
Judge, thank you for your application. Sometimes, well, let me preface the question with this. You said that the law provides the answers. As in my time as a lawyer, I find the law doesn't necessarily provide all the answers, given the facts of the case, or there might be 2 or 3 different answers. Talk about the process you go through when you're faced with that situation where it's not a clear answer, the statute isn't clear, might be vague, the cases are in conflict, or there are no cases, no precedent directly on point. So talk about your process and how you reconcile those issues.
There obviously are always those areas where there hasn't been a ruling, there's not a specific statute, there's some ambiguity where we need to look into that deeper. I think you need to be guided by whatever is the closest standard that helps with that. Obviously, in any case, the facts of it determine the outcome. So even in a case that is a type that you've seen many, many times, there may be one fact that changed a little bit. So you need to be flexible in looking at that and to use what law there is to guide you in that decision. I think one of my writing samples had included a trash rip case where there'd been a Supreme Court case that had reversed some precedent, a statute passed in response to that. That was a whole new arena that I had to go through, to do that analysis, and that's pretty indicative of how I would do that. You start with what the law is now, the history of how we got to that, if you need to get into that, if the statute isn't clear, and then come to that decision.
Thank you.
Thank you.
Commissioner Hanson.
Judge Salic, it's good to see you.
Good to see you.
Thank you for your application. How do you balance the need to process decisions quickly, but also to be thorough?
I think that's where the background of being familiar with a lot of different types of law, of being practiced in making decisions quickly comes into play. If you have that foundational knowledge, you're able to sort through things a lot more quickly. there are cases, obviously, that require a lot more time, and it's important to be able to spend the time on that, which means you have to keep up with the rest of your work to be ahead of that. But each case is entitled to the time that it takes to decide, and if one takes longer, is more complex, then it certainly needs to be given that attention.
Thank you.
Commissioner Roberts.
Yeah, sure. Maybe just to piggyback off that a little bit. I assume like at the district court level, I don't know how much. Maybe talk about your experience working through issues, or maybe you don't agree with colleagues at the district court level, or talk about like what that would be like at the Court of Appeals level, and how that experience as a judge might be similar or different to what you're currently experiencing as a district judge.
Right now, obviously, we work very independently. We're the sole person in the courtroom making the decision, and so that's quite different than the Court of Appeals, where you do have that collaborative opportunity. I think that's an interesting aspect because it allows for that full conversation that I don't necessarily have with myself. I have just the one personality. So you can try to, with your experience, go through all of those, the best that you can, but I think it adds a lot to the decision-making to have had that discussion with others, and especially given the audience for a Court of Appeals decision, it's important to have looked at it at every different angle, not just Party A and Party B, but to more fully flesh out all possibilities and how it could be read, how people could take it, because it's going to guide people's arguments for decades. So it's important to put that process in. Locally, I think in District 2A, which is where I am now, we work very well together. Again, we're all very independent, but if we have something we want to run past someone, all of my colleagues are very bright and willing to participate in those discussions to make sure I've looked at everything the right way. There's obviously things that come up that we try to deal with consistently, so that particularly in Cerro Gordo County, I split the criminal DAJ caseload with another judge to have those discussions of, what are we looking at if we decide if there's a fine for marijuana or not, so that there's not a difference in a person's access to justice because their case number was odd versus even. And obviously, we have to exercise that independently with each case, but to have kind of a framework of how we're going to handle that. We've been able to work together very well, cover for each other if there's something that comes up. I trust implicitly that someone's looking at the queue for me today while I'm gone, and when I get back, there'll be nothing for me to address unless it's really, really messy. But I think that's an important experience to have had, so you understand the value of it, so that when you do come to the Court of Appeals, that's something you continue to work together.
Commissioner Henderson.
I have no questions at this time.
Thank you.
Commissioner Sommerroth.
You mentioned your willingness to dissent when necessary if you're on a panel and you disagree with the decision. How, as a district associate court judge or as a practicing lawyer, has a dissent been helpful to you?
I think it points out things that, particularly if it's been my case where there was a dissent, I find that most helpful because I know all the facts of it, not just what may have been in the appellate decision. I think it gives you a hint into maybe a different way to have done something. If you're an attorney, a different way to argue something. For many years, we kind of had that with, if this had been brought under the Iowa Constitution, the outcome would be different, which took a little prompting, I think, probably more than it should have for practitioners to start doing that. And so now it's routine, where we have that analysis in a search and seizure, for example, under both the federal and the state constitution. So I think it's very helpful in kind of guiding different arguments, identifying things in the record that maybe would have been helpful that weren't there. I think it gives some guidance, even though it may not be binding on all of us, but it does give some good insight into how things could be done better, or what maybe the close call was on maybe one fact that the majority and the dissenter found differently.
Thank you.
Thank you.
And we don't have time for any more questions, so you are excused.
Thank you, everyone.
Again,
Good luck with your day.
thank you for your application, and we appreciate it.
Thank you.